Good afternoon, everybody. My name is Jeff Smith. I'm one of the partners here at Altitude Community Law. I am the head of our litigation department. I'm going to be going through this deeper dive into foreclosures. Kate Leeson was originally scheduled to handle this class, but unfortunately she's not feeling particularly well, so I am jumping in. So with that in mind, let's kind of move forward. All right, so before we really dive head first, just kind of some of the basics. So what is a foreclosure? Black's Law Dictionary defines foreclosure as the process by which a mortgagor or real or personal property or other owner of property subject to a lien is deprived of his interest therein, and in common usage refers to enforcement of lien, trust, deed, or mortgage in any method provided by law. So ultimately what we're talking about with foreclosure, as most of you know, is when the association steps in and tries to remove an owner from the property. Not actually remove them, but take title to the property. That's what we are talking about when we are foreclosing. We want to take their ownership interest from them and put it either in the association or in some other individual or company entity that can handle moving the property forward. That's kind of your basics of what a foreclosure is. Now, what permits an HOA to foreclose? So we have statutory ability to foreclose. Typically, there's also going to be language in your declaration that will allow you to foreclose. It's not going to be in every declaration, but it's typically spelled out that it's one of the options of the association. Now, pursuant to statute, Colorado Revised Statute 3833.3316, which is part of Kiowa, provides that an association has a lien against the owner's unit for unpaid assessments. Now, the lien is what we actually foreclose on. That's what gives us the ability to foreclose. Without a lien, you don't have the ability to foreclose. We have a statutory lien, and sometimes your association might have filed a paper lien as well. That lien is going to include the fines imposed against the unit owner, fees, charges, late charges, and attorney's fees. As the holder of a lien against the property, the HOA may foreclose upon its lien through the courts to obtain a court order to sell the property to pay the balance owed to the association. The CC&Rs also typically provide for foreclosure of the HOA lien. So, excuse me. So there's two different types of foreclosure in Colorado. You have judicial foreclosure, which is what allows the association to foreclose, and you have a public trustee foreclosure. That's how the banks are typically going to foreclose unless there's some funky issue with their own deed. Public trustee foreclosures, and we'll talk about both of these in a little more detail, but public trustee foreclosures are designed to move much quicker. You can typically get through one of those in 3 to 6 months. When we're talking about a HOA foreclosure or a judicial foreclosure, those are typically going to take 10 to 12 months or longer, depending on what's going on in the case. The reason for that is that there's multiple steps, and we'll go through kind of all the things that happen in them. But typically, it was set up for the banks to be able to move faster, and for someone else who's foreclosing on, say, a statutory lien, to take a little bit longer and give the owner a little more opportunity to take care of the issue. So the lender foreclosure or a public trustee foreclosure. With a lender mortgage foreclosure, the responsible individual signs a note for repayment of a specific sum. So when you buy that house, one of those 57 documents that you are signing is going to be a note for repayment. That deed of trust is then issued, evidencing the loan and the note, and there's a power of sale which is contained inside that deed of trust. So inside one of those documents you signed, the deed of trust, there's a power of sale. What that allows to have happen is that if you default on what you are supposed to be paying, then the public trustee, on behalf of the mortgagee or mortgagor, can initiate the foreclosure sale. So what happens is the bank tells the public trustee, by filing certain paperwork, that the owner is delinquent. The public trustee then begins the foreclosure process pursuant to that power of sale in the deed of trust. This power of sale is not something that's contained within the CC&Rs of an association, nor is it something that is contained in Kiowa. So that's why the banks have the ability to move forward in a quicker, faster manner, and why the association has to go through the more cumbersome judicial foreclosure process. Oh, sorry, pressed too many buttons. All right, so as you are all aware, over the last 6 months or so, I guess even longer than that, 1137 has been a pain in everybody's side. There's no two ways around that. It's affected collections. It's affected covenant enforcement. It certainly plays a role in foreclosures as well. So when we're talking about foreclosures in the post-1137 world, these are some of the ways that the foreclosures have been affected. One, all the notices per the collection policy must be sent to an owner, included via certified mail, posting on the unit, and that third method, before the board may vote to foreclose, even if the account was previously referred to an attorney for a collection action. So typically what's going to happen before you get to a foreclosure, association is going to go through its collection policy. It's going to send all of these notices. And then once the association has not been able to collect, the attorney for the association is going to recommend maybe we should move forward with the foreclosure. Now, if this file has been with an attorney since before the enaction of 1137, 1137 never would have been complied with. So in those cases, even though you've had it with our office before then, or any other attorney's office, before they can move forward with foreclosure, you're going to have to go through your new collection policy again and make sure that all of the requirements of 1137 have been met. Unfortunately, because it's a new action, those are the steps that are going to have to be taken. So anytime you churn a file over to our office, we're going to make sure that all of the collection policy notices have been sent to the owner. If they haven't been sent, we're going to send it back to you and say, look, you need to take care of all this. And then once that is done, you can have the vote to foreclose and send it back to our office, and then we can take further steps. Foreclosure cannot be initiated if the unpaid balance consists of just fines and associated legal fees. So that's one of the big things that 1137 did. And 1137 was promulgated basically because of two different factors. One had to do with Green Valley Ranch. They are an association that doesn't have annual dues or any kind of dues. They were just working off of fines. They have a metro district there that kind of helps, where they pay through taxes to make sure things are getting done that are need to be done by the association and district. But the association itself only had fines. And so they'd have these fines. They'd be going on for years and years, sometimes 5, 6 years, even longer. And if they couldn't ever collect on them, eventually they'd turn them over to an attorney, and that attorney would foreclose. Because there were so many foreclosures that were happening there, it drew attention of the legislature. And the legislature, well, news companies first. And then after that was done, they got the legislature involved. A couple of the, I think, House members who don't particularly like HOAs and have driven a lot of the HOA policies over the last couple of years got on board with this. They started drafting up 1137. There's another kind of driving force, which happened to be an attorney down in Parker area who was filing foreclosures basically on anything that came in. Instead of going through the normal collection policy and getting balances up a little bit higher, this individual attorney decided that, which was certainly legal within the law at that time, to move forward directly with a foreclosure as opposed to going through the smaller county court action. And so they're foreclosing on very small balances. So because of those things, 1137 came into effect. And with that, they were specifically trying to attack those issues. So in dealing with the fines issue, the legislature put in the fact that foreclosures cannot be initiated if the unpaid balance consists of just fines and the associated legal fees. So ultimately what they're saying is you don't get to lose your house anymore if you fail to pull your weeds or if you painted your house the wrong color, things along those lines. Ultimately what they're saying is that foreclosure should be reserved for people who are not paying their assessments. And so if people aren't paying their assessments and they also have violations and late fees and things like that, then at that stage the association can collect all of it. But if the owner has been paying all of their dues to the association but has simply not been paying the fines, we can no longer foreclose just on those fines. So violation, another thing that was added to 1137 or with 1137 is now the association has some skin in the game. So if the association is taking advantage of the legal system or is doing things that are not allowed, an owner now has the ability, or penalties can be issued against the association up to $25,000 plus attorney's fees and costs. So if a homeowner believes that you have initiated a foreclosure and you haven't followed 1137 to the T, and they hire an attorney, that attorney files a lawsuit or more than likely enters an appearance into the foreclosure case that the association has brought, they are, and if that owner wins, they're entitled to up to $25,000 plus attorney's fees and costs. Now, as you guys all know, when we're dealing with litigation, one, it takes a long time, and two, because it takes a long time, attorney's fees get racked up. So it'd be easy to see that the attorney's fees and costs might be more than that $25,000 of penalties as well. So the association, if it were to not follow all of its processes and have an owner sue them or file an answer saying we didn't do it and the court agree with them, association may be on the hook for $50,000 and up. So that's why I know it's a little bit frustrating for your boards and for you guys as managers, but when we get the file to our office, we want to make sure that all the I's have been dotted and all the T's have been crossed. And so oftentimes that means we have to send it back to you to go back to the board and say, look, this wasn't done properly. We got to restart the process from this point, or we got to restart it all the way from the beginning. But ultimately, we are trying to catch that on the front end to limit the liability to the association. Because obviously, no one wants $50,000 or so to be hit against the association. Associations don't have that. And that's on top of the fact that the association is still going to be owed money from the owner. So there's lots of concerns, which is why we want to make sure from the very beginning we're doing things as well as we can. Additionally, 1137 incorporated a 5-year statute of limitations for violations in terms of being able to collect fines. So if violations have occurred 6 or 7 years ago and there's fines attached from there, we wouldn't be able to go back that far. So that's just another thing to think of, another thing when we're looking at your ledgers when they come over. So that's kind of one of the things that we're looking at. In addition to 1137, certain municipalities or counties have enacted kind of their own protections for homeowners. Denver County has passed an ordinance requiring a specific foreclosure notice to be mailed to an owner a minimum of 30 days prior to instituting a foreclosure action. So in addition to if your property is within Denver County, in addition to making sure we have complied with 1137, we're also going to make sure that we've complied with the county ordinance and sent out that specific notice so that we can't be found liable for not following that process as well. So some of the things that haven't changed. So 1130, and there was already some fairly strict requirements within for how you can foreclose. And so most of those did not change. So one of that is that the past due balance must be equal to or exceed 6 months worth of assessments to initiate a foreclosure. So again, some of the times where this would be used in the past was if it was a 6 month worth of assessments, and say you had a $50 assessment, some attorneys might be looking at foreclosure 6 months after that, and the balance was only $300. Then you'd have all the attorney's fees on there, all of the late fees, all of that, and you'd be looking at a $300 balance that was being foreclosed on for $5,000, $6,000, $10,000. So those kinds of actions are what kind of spawned 1137, and that's kind of again what they're trying to look at. They didn't change how many months worth of assessments were needed, but they did make it more likely that it would be a higher balance before we could actually foreclose. Other things that have not really changed. So foreclosure for most associations is going to be a last-ditch effort. You've already gone through all of your collection tools. You've sent them multiple notices. You have probably gotten a judgment in county court. The attorney has probably tried to garnish their wages. Maybe they've tried to garnish bank accounts. So this is the only time we're really using foreclosure is for those hard to reach cases. Sometimes it's hard to reach because the owner's been avoiding service. So maybe this is a person who has lots of debtors. They don't answer the door for anyone, even the sheriffs. And so it makes it very difficult to obtain personal service. So in that type of a situation, because a foreclosure is an in rem proceeding, so it's a proceeding against the property, you don't have to serve the individual personally. We can serve via publication and or certified mail or other means of substituted service. So that's one of the advantage of the foreclosure, because when you get a foreclosure, it's not against the individual owner. Again, it's against the property. So two different kind of ways of thinking about how you can collect money. Another time that foreclosure is an effective resolution is if we have deceased owners. Deceased owners can make it very difficult because maybe it's passed on to an heir in terms of it's a son or a daughter or an aunt or an uncle. Maybe that person doesn't want the property, so they're not going to be paying anything on it. Maybe it's Maybe the person just moves in. We don't know exactly who's there. Serving on a dead person, obviously, is very difficult. And so when you use a foreclosure, most of the counties will permit service on the estate via publication. Because oftentimes when these individuals die, they don't tell us who's going to get the property. Maybe they set up a trust, maybe they didn't, maybe they have a will, maybe they haven't. We don't know who the beneficiaries are. It makes it very difficult for the association to determine who's actually responsible for this. So if we sue against the estate, that kind of gives us a road to, again, the association collecting money. Again, foreclosure may still be used in conjunction with the receivership. This is good for vacant properties, or any property that is not occupied by the owner or a family member of the owner. So in those cases, in addition to filing the foreclosure, we ask that a receiver be put into the property. That receiver is going to step into the shoes of the owner, and their job is to protect the property. So they're a court-ordered individual that is there to protect the property. So if the property is dilapidated, that receiver is going to come in and try to bring the property up to some type of a standard where it can be rented. And ideally, while it's being rented, the association would still be going forward with this foreclosure. Hopefully the association will be getting some type of money from that receivership in terms of rent that's coming in during that time period. It's also beneficial if we think that it's a property that is going to not be bid on by an investor. So if we think the association is going to keep the property, that way we already have an owner, we have a renter in there who's paying, the property's been cleaned up, and hopefully we can collect more money to pay off the amount that's owed to us before a first mortgage or the bank comes in and forecloses on us. So there are benefits, obviously, to having a receivership. There's also some risk to it. Typically, when you get a receivership in there, a receiver in there, they're going to have to spend money. That money comes from the association. So the association is going to pay the receiver the money that it needs to bring the property up into compliance. Now, again, we try and recoup that through foreclosure, but there's always the risk that we don't get that money. So there is some risk both ways, both some risk and some advantages. But foreclosures and receiverships kind of go hand in hand, and they are a very good tool to try and help move the process along. We use several receivers. One receiver we use a lot because they have a great relationship with many of the courts, and they've gone in there and explained their benefit to them, because receivership is not a common practice, especially in kind of HOA type decisions. You see receivers more often when big companies are failing or things along those lines, but they are a good tool for us in the HOA world as well. All right, so we talked briefly at the beginning about liens. And so the lien is what the association is foreclosing on. And Kiowa provides us with a statutory lien. That statutory lien attaches to the property as soon as the owner becomes delinquent. So once that owner is $5 delinquent, the association has a lien on that property for that $5. In most cases, well, liens work on priority. So in most cases, priority works on the fact of who filed their lien first. So essentially all liens are junior. Well, in this case, HOA's lien is typically at the top, but it's a bifurcated lien. So you guys have all heard of the super lien. The super lien is part of our statutory lien. We have the super lien only is an amount for 6 months. So if the owner is delinquent $10,000 and they have $100 monthly payments, your super lien is for $600. That $600 sits on top of the first mortgage. Then you'd have the first mortgage. Then you'd have the rest of the association's lien. So in our little example, $9,400. Now there are some liens that the state might have or federal government might have in terms of some taxes and things like that, that might even supersede our super lien. But it's not really all that common. Sometimes it happens, but it's pretty rare. Typically our 6-month super lien is going to be superior to anything else. So as we said, Kiowa established the priority of other liens in relation to the HOA's lien. Essentially, all liens are junior to the HOA liens, except any lien recorded prior to the declaration, which again would be something that's very rare. Typically, for that to happen, the property would have already had to, the home would have already had to be in place. Then that home would have had to join the association or become subject to that declaration for it to be recorded prior to the declaration. So while it can happen, it's pretty uncommon. The next would be the first mortgage. provided it was recorded before the assessments being collected became delinquent. So again, if the only time that wouldn't be the case is if for some reason the owner had paid off their mortgage, then they become delinquent, and perhaps they're an older individual and they want to use a reverse mortgage. So it's possible that could come into play then, but again, it's pretty rare. And then liens for real estate taxes, other governmental assessments, or charges against the unit. So again, for the most part, the association's lien is going to be the top dog in terms of its priority for the super lien portion. So Kiowa provides for an exception to the exceptions in the lien hierarchy by establishing what is referred to as the super lien priority lien, or super lien. Again, this is what we were just kind of talking about. It's the super lien. We have that 6 months that goes on top. The super lien, which is equal to 6 months worth of assessments, has a higher priority than the mortgage in the lien hierarchy. So again, when you're looking at it, you have kind of those rare governmental liens that sometimes will sit out there. Then if they're not an HOA, the next lien would be your first mortgage. Then you'd go to a second mortgage, and then you would go to whatever judgment liens, things like that. In an HOA context, you still have those state liens, state or federal liens. Then you have the 6 month super lien for the association. Then you'd have the first mortgage. Then you'd have the rest of the association's lien, and then a second mortgage, and so on down the way. So the statute allows us to have this additional priority. And the idea behind having a priority lien or a super priority lien was that back in the early 90s, when this was first going on, foreclosures could be done much quicker. And so the intent behind Kiowa in this 6 months was to help protect the association for that 6 month period of when they filed the foreclosure to when the foreclosure was expected to be done, which they felt back then could be done in 6 months. So that was supposed to protect the association, make sure they got those funds while the foreclosure was going on. At this stage, it takes longer than 6 months. Typically, like I said, it's going to be 10 to 12 months. But that's kind of the main idea as to why we had this priority lien. And typically what will happen, a lender is going to step in because they don't want to be foreclosed out. In theory, if the association files its foreclosure and the first mortgage never steps in, never files an answer, never pays the super lien, in theory, the association's foreclosure would wipe out that mortgage. So say the bank had a $500,000 loan, they're not paying any attention. Association files its foreclosure for say $10,000 or whatever it is, $20,000. The bank never files anything, so the association is foreclosing from the super lien down. In theory, the association's foreclosure would wipe out that bank's $500,000 mortgage. Now, whether that's equitable or not is of question, and against it in different jurisdictions, there's been rulings as to say whether the association really can do that or not. But if you're just reading the law, it would wipe them out. So what banks typically do is they'll get served with the notice of the foreclosure. They'll reach out to our office or whatever attorney's office there is. They'll ask for a ledger. That they will then pay their 6 months worth of assessments. So that the association gets that. And then their priority now jumps back above the association. So when the association completes its foreclosure, it would complete it subject to the first mortgage. So what that is to say is that once whoever buys the property, there's still going to be a lien on that property for, in this case, the $500,000, the amount of the bank loan. Now, if the property comes back to the association is not responsible for paying that. We have no contractual obligations. Same thing if an investor comes in and buys, they're not responsible for paying that $500,000. But if they don't pay it, the bank is going to start its own foreclosure and they'll foreclose that individual out. So typically when an investor comes in, they are going to be talking to the first mortgage and be trying to work out some type of a payoff because it's in their best interest to try and get property free and clear. So they want to work as best as they can with that mortgagee to try and make sure that they can clear it up. Oftentimes the bank is like, look, rather than going through the foreclosure process, spending all this money, presumably getting the property after foreclosure, and then having to figure out what are we going to do? Are we going to try and then sell it ourselves? I mean, all that costs money, takes time. The bank usually will allow some type of a haircut to settle it with the investor and then be done. And then the investor will either flip it, keep it for themselves, do whatever it is they're going to do with it. But that's kind of the typical process of what's going on. So again, when we're talking about the super lien, we send it to the bank. The bank then pays us. Association gets a little bit of money in. The lender will typically pay the super lien to the HOA to maintain that 100% priority of the HOA lien. And again, thus a sale of the property in HOA foreclosure will not extinguish the mortgage or deed of trust. So that's what the bank is trying to do. They're trying to protect their own assets. That's why they're going to pay that super lien. Here's just a quick slide. I know we've been talking about it and you've been following my hand signals. But when we're talking about lien priority, here's kind of what this is a good slide for you to remember. So first you're going to have those real estate taxes, governmental assessments. Number 2 is going to be the HOA, but only the super lien. So just that 6-month portion. Number 3 is going to be the mortgage or the deed of trust. Number 4 is going to be the remainder of our balance. And then number 5 is going to be all of the other recorded liens. So whether they have a second mortgage, or maybe they have a home equity line of credit. Maybe they have not been paying other bills, and so there's transcripts of judgment. Any other type of lien that someone might have on the property, that's all going to fall below. And again, if we were to be looking at this in terms of lien priority, if number 3, the mortgage or deed of trust, were to foreclose, and they go through the whole foreclosure process, number 4 and number 5 are wiped out. They don't receive any money. So with us, if we were number 2 and we're foreclosing on our super lien, the mortgage doesn't pay our super lien. If we were to foreclose on that, numbers 3, 4, and 5 would all be closed out, and they wouldn't get any money on their liens. So that's why number 3 will pay off the super lien, and then they move up to the number 2 spot, and we would move down to the 3 spot, and then we'd go forward with our foreclosure. All right, quick little rundown of the judicial foreclosure process. Now I'm going to try and get this done relatively quickly so that you guys can answer any question or ask any questions that you might have for us. Feel free to put them into the message box on your right-hand side. And while I'm doing that, I'm going to go through real quick because I totally forgot to at the beginning and let you know quickly that there's a small box on the left-hand side of the screen with the presenter, myself. On the right side of the menu, you should see a private chat icon. You can use this icon to type in your questions throughout the presentation, and questions will be addressed at the end of the webinar, time permitting. If you have any audio or video issues during the presentation, please click the no audio or video button below the presentation on your screen and follow the instructions. There's 1 CMCA credit will be automatically generated and emailed to you after the webinar, assuming you attended the entire program. These credits are not transferable. Please email Summer Sims at ssims@altitude.law or call 303-991-2076 if you have any questions about the webinar or receiving your CMCA certificate. Lastly, there will be a survey that will pop up at the end of the webinar. Please let us know what you think of the webinar. Your thoughts and opinions are important to us. Sorry, I totally forgot to read that at the beginning, so Summer's going to kill me that it's coming in the middle. All right, now back to the judicial foreclosure process. Again, this is what the HOA has to go through. This is not what the bank has to go through. So the HOA will file a lawsuit pursuant to CRCP, which is the Colorado Rules of Civil Procedure, Rule 105. This is going to be a district court action. So foreclosures, unlike your typical collections case, which is going to be done in a county court, are going to be done in district court. When you're doing things in district court versus county court, the rules are more precise. And it's less a court of equity. So you are going to, basically all that means is that the cost of these things go up. When you're in county court, you can typically keep your fees lower. When you're in district court, there's so many things you have to deal with and so many different hoops you have to jump through that it increases the cost. But district court is the only one that has venue to do a foreclosure action. The district court where you're going to be filing the foreclosure is the county where the property is located. You're going to be seeking an order and decree of foreclosure to allow the property to be sold. So when we file our complaint, what we are looking for is this decree of foreclosure, the order and decree of foreclosure. That's the court saying, yes, you do have the authority to move forward with this foreclosure, and it'll instruct the sheriff after certain steps are done to be able to actually sell the property. The owners and all lien holders of record are named as defendants and served with the summons and complaint. So before we file our complaint, we're going to run an O&E on the property, which is going to tell us the ownership and encumbrances that stand on the property. So we're going to go to a title company. We're going to ask them to research title, tell us all of the people that have any interest in this property. And sometimes we might get depending on how we're doing it, there might be a litigation guarantee, there might be other guarantees. So there's a lot of costs associated on the front end of the foreclosure. Typically, it's around, I want to say about $1,000 or so to get kind of all the title work at the beginning. And so there's that first bill when you get with a foreclosure is going to be expensive with the drafting of the complaint and getting the title work, things along those lines. But those are all things that we have to make sure that anyone who has an interest in this property is being notified so that they can either get an attorney or do whatever they need to do to try and protect their own rights. If payment is not received after we send out the complaint, the litigation process is going to continue until the case is resolved or an order and decree is issued. Once the order and decree is issued, and again, this process typically takes roughly 6 to 8 months in order for us to actually get the order and decree issued, because one, we have to serve everybody, and depending on how many people there are, that can take time. Then they all have time to file their answers, or if it's the mortgagee, maybe they're going to be giving us their super lien. So all these little steps usually take 6 or 8 months before we're going to get that order and decree from the court. Once the order and decree is issued, the sheriff is provided with the necessary documents to set a sale of the property. So with the sale of the property, there's all sorts of notice that's now going to have to be happened. So you're going to have the notice of the sales published. Typically, it's going to be done in kind of basically for cost reasons, in kind of a local publication, as opposed to, I don't know if the Denver Post is still around, but it's not going to be a huge publication. It's going to be kind of those things that are more community-based type publications. It's also going to be mailed to the owner. The owner, during all this, has lots of chances to keep their property. Even though if you read those news stories, it seems like they don't feel like there's anything they can do to keep their property. They have all sorts of, not only do they have a chance to keep their property before it got to foreclosure, in terms of paying off the delinquency when they received the 4 notices that you sent originally, when the attorney sent the initial demand letter, when the attorney got a county court order against them in the collections case, and then the board decided to move to foreclosure. And all this time, they're still getting all of these statements at any time they could cure and pay off what is owed. There really is no surprise in foreclosure. There's no reason someone should be surprised. So ultimately, up until 15 days prior to the sale, the owner can request a cure statement and pay off what is owed. Now, what's owed is going to be, if we're only 15 days prior to sale, a significant amount of money. It's going to include all the attorney fees. It's going to include all the assessments that are owed, late fees, interest, all of these things. So it is going to be a large dollar amount. However, with where we've been over the last 5 years, most homes have equity in them. Although it's not what people want to do, they could take out a HELOC to pay for this. They could take out a second mortgage. Perhaps they're getting older and they simply can't afford to live in this home anymore. They could sell and recoup all of that equity and move into wherever they're going to, wherever their next home would be. So there's lots of things that an owner can do to cure, despite what the news stories are saying. But from a strictly statutory understanding, they have up until 15 days to request that cure statement, and they have up until the date of the sale to actually provide the money. Sorry, the day before. If the default is cured by payment in full, then the sale is canceled. If payment is not received, the sheriff auctions the property to the highest bidder. So when we're talking about the bidding process, the association is going to issue what's called a paper bid. So the first bid at the foreclosure sale is going to be the HOA's bid, and that HOA bid is going to be the amount of money that is owed to the association. Again, including everything that's owed. That's including the attorney's fees, the late fees, the interest, fines, obviously assessments, since we have to have assessments to be able to move forward. So that bid is what the association is owed. That's the starting bid. If no one else bids, the association will take that property. They don't have to write a check to the sheriff. They don't do anything like that. We get the property based on that paper bid. Now, one of the things that the legislation is trying to change, and I assume they tried to pass it last year, and I assume they'll try to pass it again this year, is they don't like the idea of a $1 million property or a $500,000 property going to sale for $20,000. In their mind, the homeowner is losing all the equity that they have in the property, and that is not fair. So what they've been trying to push is that the association the property has to sell for 80% of fair market value, or whatever number they decide. 80% is kind of what they've been looking at. If that were the case, and we're talking about $1 million property, association is owed $20,000. In order for the association to move forward with foreclosure, they would have to do an opening bid of $800,000. So the association would have to come up with 780 grand out of its pocket to try and move forward with the foreclosure. That's not going to happen. That's not possible for an association probably to do. Very few associations, if any, are going to have that much money on hand. So if that does change, foreclosures for associations will more than likely stop. We are trying to inform the legislature that that is not a practical solution. But you never know. Just so you guys are aware, that is a possibility. With the new task force, I would be shocked if they're not discussing it. You see in the news articles out there that the news is talking about it and feeling how owners losing all of their equity isn't fair, which again really isn't the true story in terms of there's lots of ways that they can maintain that equity. They're just choosing not to take any of those steps. So again, talking about going back to the bidding process though, the paper bid where we're at currently today, the association only has to put up what is owed. If no one buys it, then the association gets it, again, subject to a first mortgage or the other priority liens that we talked about briefly that aren't very common. If an investor comes in and buys, which is great, investor comes in and buys, association, the investor will pay off the association. If there's any money left over from that, it's what we call an overbid. And so the other junior lien holders may have the ability to submit funds to get paid off by the overbid. So if say we were owed $20,000, investor comes in, buys it for $40,000, there's $20,000 worth of overbid. The first person who's going to get that, if there is a first mortgage, is going to be the first mortgage. That 20 grand will go to the first mortgage. More than likely, the first mortgage is still going to be owed a lot more money, and they're going to go and they still have the ability to collect. And what I'm talking about, sorry, I shouldn't have said first mortgage. It's going to go to the junior lien holder, the first priority junior lien holder, not the first mortgage. So if there's a second mortgage on the property and they're owed 60 grand, there's 20 grand in overbid, they would be able to collect that full 20 grand. But the rest of their lien is going to be wiped out. In terms of the priority lien holder, the first bank, their lien is not going to be wiped out at all. They still have the ability to go through with their own foreclosure, which we talked about a little bit briefly earlier. So overbid funds in bid of excess of the amount owed to the HOA, again, like we said, may be claimed by the junior lien holders. If no claims are made or additional funds remain, the funds belong to the prior owner of the property. So there's a process that the junior lien holders have to go through and file before they can be given that money. If they don't do it, then that money can be turned back over to the owner. And then again, the first mortgage is going to be doing whatever they have contractually to try and collect that money. Again, as we've talked about briefly, a typical uncontested judicial foreclosure generally takes 10 to 12 months for the filing of a lawsuit to the sale of the property. It can certainly take longer. It's rarely going to take less time than that. But that's kind of your average range is going to be 10 to 12 months. So it's a good thing to either have the attorney come in and talk to the board, or you as managers talk to the board and discuss with them a realistic time frame. Because oftentimes, as we all know, more information is better for the board. And so if they're thinking this is only going to take 3 months and we're 10 to 12 months down the road and they're like, why hasn't this happened? That's going to change their expectations. So the more that we can do to balance their expectations from the beginning and let them know this is a long process. It does have many steps. There will be every couple of months you're going to be hearing from the attorney with an update as to what's going on and what the next steps are going to be. Just managing those expectations from the get-go is much better. It's much easier to manage how they're going to respond to all this because it is a lengthy process. They're going to see legal fees being billed on a monthly basis. And so we want to make sure they have a full understanding of what exactly this is going to take. So what happens if there's no bids? So association put up its paper bid, no one else bids on the property. The HOA, in those cases, the HOA is going to receive title of the property and may keep it subject to the first mortgage or resell it and retain any proceeds. Again, when you are doing this, if the association becomes the owner, you're also going to have to insure the property. You're going to have to be paying the monthly assessments. the association is the owner, so they're going to have all the same obligations that an owner has. So that's one thing you have to think about. Some associations might try to negotiate with that first mortgage, see if they can't come up with a deal to pay them off so the association owns it free and clear, and then the association can flip it or do whatever they want with that property. That's really only going to work with an association that has a fair amount of money, more than likely, but it is a possibility. Another issue that's going to happen is if we get the property at foreclosure and the owner or tenants don't voluntarily move out, then the HOA is going to have to evict. The eviction process is not overly complicated, but is sometimes a pain. It's usually going to take you, again, probably 60 days on average. If everything were to work out perfectly, you might be able to get it done in 30 to 45 days, but more than likely it's going to be a little bit longer than that. When we're talking soups and nuts, from the time that we move forward with all the process, we're going to have to post notice on there about they have to get out. We're going to have to then go to court hearings if they fight it. It takes a little bit of time. So I would always, again, you might be able to get it done in 30 to 45 days, but I always, again, like to manage expectations, so I like to put it a little bit more on the high side. If a first mortgage exists, it will have to be paid upon sale of the property, or the lender will foreclose on its lien. So again, if the association takes the property and we don't work anything out with the lender, eventually the lender is going to realize that this foreclosure happened, they're not getting paid, and they're going to try and do their own foreclosure. Ideally, we want to be done with that property by the time a lender tries to do any of its foreclosure actions. All of the lien holders except taxes and governmental liens are extinguished by the sale, which is what we're talking about. So the junior lien holders get wiped out, so they're no longer on the property. So we're only dealing with those priority lien holders, such as the first mortgage and those tax and governmental liens. All right, quickly in terms of a PT foreclosure. So what happens if the lender starts a foreclosure? So due to the expedited process for a lender foreclosure, each HOA case is reviewed to determine the best course of action. So if we get a file turned over to us from the association, we're doing our background checks, we're looking to see where exactly anything is. If we come across the fact that the public trustee has started a foreclosure already, more than likely, we're not going to recommend the association going through its own foreclosure. The reason for this is because the bank can do it much faster than we can. So if the bank is on top of their game and they can get it done in 3 to 6 months, all the association is going to do by doing its own foreclosure is spending good money after bad. And so we don't ever want that to happen. So in that case, the association, the attorney is going to likely talk to the board and say, here's what's going on. We will explain to you your options. And it's possible that the board still might want us to do something because PT foreclosures do get continued. A public trustee foreclosure has the ability to be continued up to 1 year from the date of the notice of election and demand, or the NAD. And so there is a possibility that they just keep continuing it. We could get our foreclosure done before them, but it's pretty unlikely. So your HOA attorney will walk you through that and kind of walk your board through that and explain to them what we think the best course of action is. What's more likely to happen is the association has started its foreclosure, and we're maybe 3 months in, 4 months in, and then the bank starts its own foreclosure. And at that time, we're kind of in a race. So again, the association attorney is going to talk to you. Maybe they'll recommend that the HOA foreclosure be placed on hold to monitor the lender's foreclosure. Or we're going to say, let's continue to get the sale before the lender does. So again, it's going to depend on where we are in it in terms of the timing. But those are kind of the options that the HOA attorney is going to talk to you about and talk to the board about. And again, the concern is always going to be association spends 10, 15 grand on a foreclosure and the bank beats us to it. They foreclose. And now all of a sudden the association, instead of being out just what the owner owed us, we're now out both what the owner owed us and all of our attorney's fees that we just paid. So that's what we're always kind of looking for and trying to constantly deal with. That's what you'll hear from Kate about a lot in terms of here's what's going on. Make sure you are looking at your status reports and things like that so that you're aware of it. And if you have questions and the board's looking at, to make sure that everyone's on the same page. So PT foreclosures go through a Rule 120. That's why it's one of the ways that make it easy for them to go through. It's kind of almost like if you guys have done an amendment process recently and you're going through the court petition, same kind of thing. Basically, all that has to happen is if the bank shows that it's done X, Y, Z, the court doesn't get to overrule what's going on. Ultimately, you have a checklist. If you've done all those things on the checklist, the court's going to approve the foreclosure. So lenders generally wait until a loan is in default at least 3 months before foreclosing. I mean, to be honest with you, typically they don't start their foreclosure until an owner is a year or more delinquent. Even sometimes it might be 2 or 3, depending on where we're at. Right now, because there is equity in properties, they're moving them a little bit faster. But when we fall into a recession or the economy starts to slow down and they get overwhelmed with people not paying, back in the 2008, 2009, people were delinquent for 2-3 years before a foreclosure would take place. So it'll vary from bank to bank, and the bigger banks are typically going to be, because they're dealing with so many of them, you might have a little more leeway in terms of how long you'll be delinquent before they're going to foreclose. But ultimately, at some stage, they're going to catch up to it and figure it out, and they'll start the process. When they're doing it, the lender will send their foreclosure documents to the public trustee. They record that notice of election and demand, the NED. That's what allows them, from the date that that's recorded, they have 1 year to complete the foreclosure sale. So again, that can keep getting continued out until you have that 1 year. They're going to set a sale about 4 months in the future, and then again they can keep continuing it and keep continuing it. Once it reaches that year, if they have not gone through the foreclosure, then they'd have to rescind that NED. And if they want to do it again, they have to start the whole process over. A Rule 120 hearing is held prior to the sale to establish the lender has the right to foreclose. Again, this is the hearing that's similar to a amendment if you're going through the court petition process, where they just have to show that they've done all the statutory requirements, and once they've shown that, the court's going to sign off on it. If the owner does not cure the default, the property will be sold to the higher bidder. Any junior lien holder, including the HOA, may redeem following the sale by paying the amount of the high bid plus nominal interest. So redeeming is just ultimate happens. If an investor comes in, they pay $110,000. The association wants that property. The association can pay that winning party as a junior lien holder that $110,000 plus some interest and costs, and the association would then get the property. It's very uncommon for an association to want to redeem property, but sometimes they do. More likely what's going to happen is the HOA may receive an offer from a third party to sell the junior lien. Investors obviously typically have more cash on hand, so if they can get themselves into the position of a junior lien holder, they then have the ability to redeem the property, and then they can get the property at that price rather than having to go through the bidding process and maybe bid the property up even higher than what they would have paid. So if the association is approached by a third party, an investor, and they want to purchase the HOA lien, they'll usually contact our office. We'll reach out to the association what the offer is. Most of the time, the association is going to get paid in full. Occasionally, the investor might be asking for less and might be asking to have the lien sold for less. In those cases, the attorney is going to talk to you about pros and cons as to why it might make sense in this situation to accept less. But almost always, we're going to get paid in full. Once we're paid in full, we're out of it. The investor takes over for that junior lien position, and what they do with it, they do with it. Every once in a while, you have some investors who are not quite as above board as others, and so they might take additional steps that maybe they shouldn't be taking, which is why we try to make sure that the HOA is completely out of it. Every once in a while, the HOA might get pulled in on some ancillary lawsuit, but for the most part, once it's sold to the investor, we're done. We don't have to worry about anything else. As we're talking about, the investor stands in the shoes of the HOA, so they can redeem the property from the sale, and that way they don't have to engage in the bidding process. If there are overbid funds from the sale, so it's a PT sale, there's overbid. We're a junior lien holder in the overbid in this scenario, so the association has the ability to request those overbid funds. The HOA, we file the paperwork, we try to get whatever money we can. Sometimes you get everything. Sometimes you might get a nominal amount. It just depends on how much the overbid is there, how much overbid is there. But that is one way for the HOA to try and get some money back as well in the PT foreclosure sale. If the HOA does not redeem and there are no overbid funds, the HOA is not going to collect anything from the sale other than the amount of the super lien. So all you're going to get is a 6-month super lien. Your lien on the property is extinguished by the sale, so there's nothing we can do in terms of foreclosure anymore. It does not take away the owner's personal liability in terms of being able to go after that individual still from a personal standpoint. However, that personal obligation, if an owner's gone through foreclosure, more than likely they don't have any money. Their greatest asset is going to be the home. The asset's now gone. They don't have anything that more than likely is going to be able to pay off the association. So more than likely you're going to be writing off this as bad debt, unfortunately. So it's just kind of the reality. It's not happening as much as of right now, but if we have a downturn, it wouldn't be surprising to see that happen. So as we're talking about, the declaration is going to impose that personal obligation on the owner for payment of the assessments that become due in the period of ownership. But if we don't have the lien on the property, the HOA is limited to personally collecting from the owner. As we were saying, in most instances, the individual owner no longer has any assets, as the unit or home was their major asset. It also becomes more difficult to locate and serve the individual. They've now moved somewhere else. Maybe it's an apartment, maybe it's whatever, maybe they moved in with family, but they're harder to find. My screen just flickered. I don't know if your guys' screen just flickered and changed signs on me. Hang on. There we go. Even if the individual can be located for service of the lawsuit and a money judgment is entered, we still have to then find assets. So even if we get them served, we find them, we get them served, we get a judgment now, say for 20 grand, 10 grand, whatever it is, we still have to then be able to collect that judgment. So again, we have the only way we're going to be able to collect through these ones are going to be a bank garnishment or a wage garnishment. And so with the high dollar amount that we're talking about, the likelihood is you're not going to see that money. It's an unfortunate proposition for the HOA, but that's unfortunately what happens from time to time. Is if people don't have money, I mean, again, you can't get blood from a turnip, so you can only do so much. All right, that is the end of our presentation. We got 8 minutes for questions. I see one question right now. Are HOA assessments included in bankruptcy? How do we get notice? So a little bit outside of the scope of this, but if an owner files a bankruptcy and the owner is delinquent on their assessments at that time, the owner should include the association as a creditor, and the association should get notice of that. If the owner is not delinquent at the time of the bankruptcy being filed, then the association is not technically a creditor at that time and may not get notice. There's an argument that because there is an ongoing obligation that they should get notice. But again, that's going a little more into the bankruptcy law than we probably need to get to. Typically, when we get a file in our office, the first thing that we are going to do is make sure that the owner is not in bankruptcy. It's one of the checks that we run. If the owner is in bankruptcy, we'll let you know. And then the attorney at that time can kind of walk you through what options the association has. Another question, how much are the legal fees typically for planning purposes for a foreclosure? I mean, each one is going to be somewhat different, but we'd always say planning on roughly, we would say probably $7,500 at the bare minimum of what a foreclosure is going to take. If we have to go all the way, if we have to have a trial and then go all the way through sale, that number can exponentially increase. The vast majority of people do not file an answer to our complaint for the foreclosure. So oftentimes we get the order and decree without having to go through a trial per se. We'll get kind of default judgment. So when that happens, you're going to be talking more around the $7,500. If you are doing if the owner responds and they fight and they get an attorney, or some other party fights and gets an attorney, just like with any litigation case, I mean, it could be $15,000, $20,000 of attorney's fees, $30,000, $40,000. I mean, it can go depending on how hard they fight and how much they want to do. But when you're just looking at it originally, mostly when we talk about 7,500 to 10 grand is your typical one, but that certainly can increase from there. What if the owner wants a payment plan to repayment of their delinquent assets? What is that process? Owner wants a payment plan for the repayment of their delinquent assets. So again, before you can get to foreclosure, you have to go through your collection process. So in that collection process, they have to be offered the payment plan. And so if we've gone through all of that and they've defaulted on the payment plan that they've already had, or they have never entered into a payment plan, once you get to the foreclosure, we've already gone past the collections part of it. So we've already offered that. They haven't accepted it. Your attorney will then talk to you if the owner wants to enter into a payment plan and let you know, does this one make sense? Does it not make sense? Maybe they're asking for too long. But the statutory side of us already offering them, by the time we're at foreclosure, has already taken place. So there would be nothing that would require us at that stage to enter into a payment plan because the owner had already passed on that when we went through the collection process. But your attorney will walk you through whether it makes sense to accept a payment plan in this one. Typically, a payment plan in a foreclosure action is going to be shorter, though, because we want to keep the process going throughout so that the association gets its money as quick as it can. If there's no mortgage on the home, does that make it easier to get the HOA money that is due? So yeah, two ways two things that are good for an association to see. One, if there's no mortgage on the home, that's great because the owner, typically the home's going to be worth substantially more than what the association is owed. So that owner has lots of different options. One, they might refinance the property. They might take out a loan because there's nothing else encumbering the property. So they have access to more money to pay the association quicker. So that's one way that makes it easier. Another thing that makes it easier is that if we were to sell it, we own it outright. If we were to foreclose, we would own it outright. So the association would have that property, and it could become a great asset to the association. Another thing that we like to see when we're doing a foreclosure review is a large second mortgage. When the association forecloses, it wipes out a second mortgage. So if the second mortgage is owed 100 grand, 150 grand, the association is only owed 20 grand, it's not uncommon that that second mortgage, to protect their 100 or 150 grand, will pay the association its $20,000 to make the association go away and protect its rights, and then it'll tack that 20 grand onto the loan that's already owed by the owner. So those are two situations that are great for an association to see. All right, with that, that's the last question that what process exists to collect on delinquent fees only? So what process exists to collect? So if you only have, I assume what you're talking about is like fines. If there's only fines that are out there, you're going to have to go through just the normal collections process. And you'd be just filing a county court action, personal judgment. But what you don't get to do is attach that to the home and then foreclose. So you can collect on fines, just fines. You just can't foreclose on them. So it would still be a money judgment against an owner in a county court. Well, hopefully that has answered all of your questions. If you have any, feel free to contact myself. Last slide has my email address. You can also contact Kate Leeson at kleason, Leason, at altitude.law with any of your questions. And hope you guys have a good rest of your Wednesday. Take care.